I'd like to welcome everyone to the March meeting of the Richmond ISD Square chapter. Thank you, Mark, for hosting the meeting this month. Like I stated earlier, very nice facility. I don't know how you are you leasing space? Is this a common space?
We do lease space. This room is our room because this is where we do our homeless veteran training. But it's not our space to take over.
Got it. So I'm going to keep it short and sweet because everybody here has been to one of our meetings before. I'm Ivan Gill. This is Chris Sherman. I'm the president, by the way. Chris Sherman, vice president. Michael Stapleton, the treasurer, and David Brown, the secretary. Did I miss anybody? Oh, the membership chair. This month, we're going to have Greg Bell do a presentation on forensics, computer forensics. Is that right? And I don't have much else to say tonight, other than giving Mark a couple minutes to introduce himself, his organization, which is a phenomenal organization, and take it away.
Thank you. Welcome to Tech Church, everybody. I do appreciate you coming in and seeing our place. First things first, if you need to go to the bathroom, right down the hallway, left-hand side, men's and women's. On your nose. Okay? That's the first thing. The second thing is, I don't know if you've heard of us. You may not have heard of Tech Troops. We refurbish computers, give them to veterans and the families of veterans for free. Now, it's not just any veteran, it's veterans who are in need. So, poverty or homeless. We train homeless veterans in here. I've been up to Martinsburg, West Virginia, Martinsburg, and get them mixed up. West Virginia, and train the veterans up there as well. So, we do that as well as recycling and art program, and then of course refurbishing. We only hire that. So we give them the ability, the skills, the IT to get out of poverty and to get a better job. Our biggest success story at this point is the gentleman who used to work here. He's now working at Pentagon. That's really cool. So that's us in a nutshell. I'll be here until you guys leave. I ask that you don't leave out of here by 10 o'clock at night because I'm going to be back here at 7:30 in the morning. Right? So, but I'll be here too. If you want to take a tour, I'd be happy to give you a tour afterwards. All right? I'm going to let y'all get to work. I'm going to go do some work. So,
thank you. And without further ado, I turn it over to Mr. Dr. Greg Bell.
Has anyone ever done computer forensics or know what it's about? So kind of give me your definition, because I see it like hands up and down and type stuff. What do you think computer forensics is?
You're trying to get information that you're just looking for information on the computer to give you some type of trail to the answer.
Okay, I mean, it's the forensic portion means getting evidence or information admitted into court. And so computer forensics is getting computer data admitted into court. Computer forensics in this day and age is really a misnomer, right? Because we've got evidence on phones, on GPS systems, your car itself, you can do forensics over.
Sorry, I meant to, one more housekeeping. I just locked the outside doors. So if any of you get a text or a call saying, hey, I can't get in, if there's anybody else coming, just let me know, okay?
And if there's a fire, do we just come run for you, or?
Sure, you can do that. There's plenty of exits here, though. But yes, no. All right, but I just want to let you know, if you get a text saying, I can't get in, just the glass doors right there. All right, thank you.
So cars themselves, evidence from those or digital evidence on there for like a murder scene to see whether a car was in a specific area could be used as well. So it's a process whereby you take electronic data and get it admitted into court. There's how do you do that? Right? Because you have chain of custody, you have all these other issues that the court is cares about. This works. Okay, so in the computer world, what kind of cases are typically used for digital forensics or computer forensics? It's every kind of case, right? And these are some of the cases I've worked on. And in addition, I actually did a case down in Colonial Heights where the court needed to understand Facebook because apparently there was a gang type murder that really wasn't a gang. It was someone who was getting a divorce, ended up getting drunk, and she called him up disputing. He ended up saying, well, if you come over here, I'll kill that SOB. So she decides, let's test it. So she shows up there with her boyfriend. She's still married, with her boyfriend and a friend, and they considered that a gang in Colonial Heights. So they're wrestling on the ground, just normal wrestling, and he stood up, and her friend kicked him, held back, hit his head, and ended up dying. So they considered it a murder, and it was a gang-related murder. And because Colonial Heights is so small, everything was posted on Facebook, and basically they couldn't have a fair trial because everyone knew about it. So the judge asked me to come in and give him an understanding of Facebook. Now that shows you alone how backwards the court systems are, because the courts, the judges and the lawyers spend all the time in court and really don't do a lot on Facebook or social media. And they need to understand what is that. So here's some of the other different law categories that digital evidence can be used for, from criminal to civil or administrative. And administrative can be penalties, wrongdoings, etc. I think we kind of understand what criminal or civil law is, but it's important to note that even the cases where it's a divorce, spousal, someone's hiding money, can use digital forensics as well. So how does it happen? So the fight against computer crimes, when you look at that, it's twofold. It's kind of what our jobs are, right? Is we're trying to prevent it, but we're also trying to respond to incidents that occur. So the incidents that do occur is typically how computer forensics starts out. Because when you do incident response, at the very beginning, you don't know if that evidence will end up going to court or what happened is a crime. And it's as you're going through your incident response, you realize, wait a minute, we got a hacker, we got an IP address, maybe the FBI or others can follow this down, et cetera, and it could turn into either civil or criminal, but you don't know the extent of what happened. So they're hard to prosecute. And the biggest reason really is because lawyers and judges don't understand it. They don't understand that every crime or any incident, civil or criminal, needs digital forensics. And they don't understand how to admit that evidence in the court. So many times where I'm asked to participate, and many of you may be asked to participate, is really from a lawyer's perspective of, I have a deposition, what questions should I ask? Because I don't understand computers, I don't understand security. What does it take? What should I be asking him? And yes, as far as the chain of custody and admissibility of that evidence, whether or not it's authentic, et cetera, are the type of questions that you're going to try to target so that the lawyer is prepared when he goes in there. Also, when you're giving your evidence, whether or not you're on the stand or in the deposition, it's important to be able to articulate what is that, what is a computer? Because, I had a case in Louisa County where it was just phenomenal that many of the people even on that jury didn't have a computer. It's kind of floored me in a way, because this is 1 year and you don't have a computer? But in some areas, people can't afford it, et cetera, which is great that this organization has that ability to do that. right? The federal rules of evidence are set procedures that help get information admitted into court, right? The rules that govern the admissibility of it, whether or not there's chain of custody, and how the evidence is handled. Right? So from the very beginning, when you first hear about it, when someone calls up and says, something's happening on my computer, from that point forward, you start documenting. You document the fact that someone called at this time. I have a, so now I work for the Commonwealth, and I have one right now where it's considered gang stalking. One of our employees actually, hopefully there's no TV recording, but one of our, yeah, all right, well, I'm careful. A gang has targeted one of our employees to the extent that the state police has said, move out, and you need to not tell anyone where you're going. So at that point, you know, the computer is state property, so we have to do digital forensics over there for state police and get everything prepared. We have to follow these rules. So what rules are there? Well, freezing the scene itself, right? So capturing it. And when I say freezing the scene, that's almost taking pictures of the scene, taking pictures of, you know, every wire that's connected in the computer, whether or not it's connected electronically, network, et cetera, so you know the access points, and then anything around it. So sometimes when you take pictures, you'll notice, you know, a thumb drive is here, or a DVD or a CD, and that has to be accounted for later as well. So when you freeze the scene, really it's a formal process to be able to pull all that information in so that, you know, the jury later on understands exactly what you were presenting with. Okay, maintaining chain continuity of evidence. This means that if you have a computer and you pull out the hard drive, that hard drive is the original evidence. You have to be able to account for it the same way as if it was a murder weapon, if it was a gun, if it was a knife. Who had access to it at any, from the time you took control of the evidence until it's presented in court, and even afterwards when it goes to appeal, if it does. So, and then take your witness statements. Many times your witness statements are questions you're asking about passwords, that type of thing. If you have a cooperative witness, then it's much easier, right? Because they're willing to give you everything. They're willing to sign the statement saying, I waive my Fourth Amendment right to search and seizure. Which is always kind of a question, because I'm not a constitutional type person, but I'm always amazed by how many people don't understand their Fourth Amendment. Does anyone know what the Fourth Amendment stands for?
Isn't it for search?
Search and seizure, not quite. It's the right to privacy. So a woman brings in a purse into work, the employer can't go through the purse, which I've had cases where employers have done that. They can't just seize, right? They can't say, give me your wallet, they can't. Where that's relevant in digital forensics is that you can't force someone to incriminate themselves, right, which is what constitutional. There you go. So you can't tell them, you must tell me the password, because it's something they know, and by giving you the password, if you find bad stuff, they've incriminated themselves, so they can say no. Now, I say that it's a Fifth Amendment issue, but the different courts have ruled differently. Different states have ruled differently on that, and it's one of those things that are challenged quite frequently in courts, and it's been challenged several times to the point that it can go either way, right? But if you take pictures, if someone wrote it down, that's fair game. So you're looking for all those papers where they may have wrote down the password next to your computer. That actually is helpful to you. So lack of security helps you. All right, so why? The authenticity aspect of it, right? You have to be able to prove that that evidence is the authentic, original evidence. And those are defined based on independent checking, based upon well-defined procedures, checklists that you have on your process that you've gone through. Okay. Admissibility, when we talk about that, those are the legal rules which the determine whether evidence can be considered in court. Admissibility looks heavily upon the chain of custody who had access to that as well.
Quick question.
Mm-hmm.
So you do an image of a hard drive. How does the court know that they can trust that?
Okay, so that's a good question, and it's kind of a little bit later on, but let me address it. So when we talk about copying a hard drive, right, it's not a copy like a ghost copy where you've cloned the computer or the hard drive, because it has to be a bit for bit copy of that. In other words, if in 0001 it's a 1, and on this one it's a 1. Where you do a clone, it looks for all your active allocated sectors and just moves it over as a clone, right? So it tries to condense things so everything's in one spot when you clone. When you're doing a bit for bit, if there's unallocated space between programs, then it will be the same on the new hard drive. And so to that end, let me just talk about that for a second. When you do a hard drive, does everyone understand how a hard drive works? I know some of you do, but maybe not everyone. And a hard drive works by the spinning around, the head going back and forth, looking for stuff, right? But at the very beginning of it, there's what's called the file allocation table, or basically a table to say where everything is on the hard drive. So it has your file header information, it has information about dates, etc., of the file or executable that's stored on the hard drive. It'll say it's starting at this position on the hard drive and it goes for this long. Now that can be broken up later on, because when you actually go to that spot, it may say this is continued on another area. But because of it, there being a table saying where everything is, there's empty room in there. So when you do that bit for bit copy, the forensic image, it moves everything and makes it identical. The way in which you prove that to the court is with your MD5 hash and SHA. So you're actually doing your checks on there and coming up with your hashes, and you compare that to the hash of your nuke. Yes?
So how do the courts accept MD5 and SHA-1 that has been proven to be broken?
MD5 has, not SHA.
SHA-1 has been broken as well.
Yeah, but it's SHA-2. So, yes. And, but in addition to that, they usually, when I do them, I do all, right? And I show all the different hashes so that if it's used later. I'll be honest, the best way to do this is that when you pull out the actual hard drive, you make 2 images of the hard drive. You store that original in some place. So if there's questions later in the court, or the opposing counsel wants to ensure that it was, and they bring in an expert, you actually have the original, and you say, all right, let's do the comparisons, and then they'll come in and verify that it actually is the same. So keeping the original at all times is important, and that's something that you store in a safe place. Okay, so that's pretty much how the court has determined that it is the original. Using tools to do it, there's specific tools, hardware and software, that you use to do your file copies over. Because anyone who knows, if you just plug in a USB device or a hard drive onto your computer, the first thing the computer does is go out there and say, what is this, right? It uses a interrupt 13 to say, what are you? And then reports back saying this is. When it actually goes out there and say, what are you? It changes the last access date, which is important, because if you then use that and then store that, it's going to have the date that you accessed it. So the opposing side, when they do their comparison, will say, well, yeah, this crime occurred on January 1st, but the last access was March 26th. You changed the evidence when you did the copy. So you have to use write blockers to ensure that it doesn't change any of that information. But I'm getting ahead of myself here a little bit. So here's some additional information that, was the admissibility was developed in England. trend was towards increasing the formality of it, the process. There's also the admissibility of documents, the original documents, and there's some actual references here. What they've actually shown is that if a report from the courts is a paper document, right? It's a normal course of business. So you do a report, and you have a report coming out every day that shows the number of incidents, security incidents you had. It's a normal course of business. Every day I get this report. That report, whether that's printed or electronic, is admissible into court. If as a security professional you say, I want to see in the audit logs, I want to run a report of who accessed our system yesterday, that's not a normal report and it would not be admissible in court. Right? So there's some differences there. So you get a normal audit reports, it's actually helpful from a legal standpoint because that's part of your normal process. And by doing so, it's admitted into court. Okay. There's problems about the novel scientific evidence, Dalbert, which I'll talk about in a second here.
So Greg, back up a second. So I'm an ISO or a CIO at a company, and I get these normal reports of audits, right? Whether it's access or whatever type of audit I'm getting in those reports. And then I find out that there's been a breach, and I request an additional report specifically concerning that breach. That is not admissible?
It would depend on the reliability of the reports that you currently get. So if you asking for an additional report or additional evidence, right? Are you basing the decision upon the report you have, and you're looking at that and seeing an abnormality, and you're saying, I need to investigate this abnormality?
Yes.
So in that case, the answer is yes, it would be. If someone comes to you and says, something bad I think is happening, right? And you say, I need to run a report, and no. So it gets a little bit tricky in there for the lawyers, right? I mean, they're going to push it forward, but the other side, if the other side's smart, the opposing counsel's smart, they'll raise that as an issue, and most likely the judge is going to favor that because of it.
Interesting.
Yeah.
So are you familiar with Splunk?
Yes.
Okay, so Splunk can pull all kinds of data, right? From all kinds of sources. And you can create all these different dashboards. And I can go into Splunk and point out an anomaly, right? And drill down.
Is it your normal course of business as an employee to go in there on a daily basis and look for abnormalities and create reports? See the difference? There's a little gotcha. If the answer is yes, then yes. If the answer is no, I'm just, then no.
What if you should have found it from that original report anyway? You should have been able to find
Well,
there was an issue, but then it came in a different avenue. Is there a correlation to be made to bring that other avenue into this?
Again, it would be based upon your decision of doing it. Now, most likely, if it's in the report, you didn't see in the report, and someone came and said, hey, there's this problem, and you said, oh gosh, someone should have caught that in the report. Let me get this additional report. Most likely, because you showed a correlation between it, it would be admissible in the court. You most likely are not going to testify or asked to be testified because that would be an issue for your counsel, right? Because they do not want you to open that door if you're asked. All right, so novel evidence, and I was talking about the Delaware test, which is based upon a court ruling, which is on the previous slide. I think I jumped. But there's actually a court case that this came out of why we should allow evidence or digital evidence in the court, right? Or scientific evidence as a whole, even DNA in that. It's whether the theory or technique can be, has been tested, the error rate associated with the method, publication and peer review. So if you have software has to go through these Doppler tests to show that, yes, it's repeatable. And, every time you run a test on this hard drive, you're going to come up with the same results. And that's kind of where they're going with this, whether or not it's gained widespread acceptance. So some of the forensic tools out there, EnCase, FTK, are probably the biggest ones. There's also Celebrite for mobile evidence, which is kind of funny because digital evidence as a whole, we kind of think of hard drives in that, and the leader in that has always been EnCase and FTK. But more and more we're moving to tablets, and tablets, you want to use Celebrite or those type of tools because SSD in that, and it works better with that tool to be able to retrieve the evidence and do your image. So EnCase and FTK have started moving more towards mobile solutions and mobile tools, and Celebrite that has always been the leader, so they're loving it because they're seeing an adoption rate higher. I'll say. So when we talk about computer forensics, I mean, what does the court actually look at? Decisions are not really scientific in the judge's and jury's mind. They are thinking more along these questions here. Was a contract broken? Was there a breach of duty? Was someone defamed? They're not looking at it from the same aspect as a security professional would be looking at this at, right? Or the counsel, because they have a different slant of the evidence itself. Right, some other things, the test in court is based on probabilities, reasonable doubt, preponderance of evidence, and the evidence from the scientific and experts are only part of the overall mix. So legal proof is what's demonstrated before the court. So has anyone been in court before and testified? Okay, so what is really unique about testifying in court, and I've got some slides on this later that I can talk about as well, but to me, it seemed like more theatrics than actually anything, right? Because before the jury's there, like the night before the trial, the expert, my case, I came in there, and the opposing counsel, your lawyer, the judge, all sit in the room about what they're going to do the next day. We have a presentation, right? We did a PowerPoint slide, and you did screenshots in the opposing counsel, and you highlighted something. So, because you want the jury to be able to see this evidence on your slide, right? The opposing counsel at the pre-trial will say, Your Honor, I object to that evidence because it's not the exact image that would have been seen on it, right? So that night you gotta remove all of your highlighting and everything else so that it's the exact thing, right? And then you do that, and then the next day the trial starts, and you go through all the preliminaries, sworn in, and all that stuff, right? And the night before, everyone's joking, everyone's talking, and then the trial starts, and everyone, it's like this, you could hear a pin drop, and everyone's very antagonistic, and not looking in the eye, and then you get up there, and immediately they start, Your Honor, I object to that. I don't think they should even have PowerPoint presentations. You're looking at them going, well, last night you said it was fine. Now you're saying it's not, but they do that for the jury as well, and probably so that they have an appeals process, right? But it's very unique to me in that what's agreed upon the night before, sometimes even during the trial, maybe they slept on it overnight, had a different opinion to themselves, but it's not what happens during the trial. And it seems that everything is kind of, even the standing up, the moving around, seems like they're doing it for the jury, right? And to me, it seems like you're watching a movie rather than a trial.
Maybe it's a rabbit trail. I mean, it's like they don't care about the truth.
That's what I felt. Now, I don't know if that's true or not, but I just felt like it's almost like things were kind of predetermined and on what was going to happen, right? And the decision hasn't been made, but how it's going to be presented has been. And so then it's presented, and yes, you know, I guess it's anyone's guess on how it's going to land or how people are going to perceive what happened. But it just seems like it was a lot of theatrics around presenting it to the person. So, you know, we've always heard perception's reality, and it just seems like there's a lot of perception going on to get people to sway one way or the other.
Is that the same for a non-jury trial?
I don't know. I didn't have, so everyone I've been in has been everyone I've been in has had a jury trial. So I haven't had the instance where the judge would show up and then have a change. It seems to me that since he's part of the pre-trial meeting, that he wouldn't participate in that portion. But I have, to be honest, I mean, I wouldn't know. So legal proof is about arriving at a conclusion from a specific set of circumstances. Okay, so intended computer records, these are what I was talking about, the computer documents, whether or not they're regular computer reports. And that's important for the courts. You know, we all think, well, you know, I do ad hoc every day. You know, I have to be able to look at different stuff, and I can't just, if I get a normal report saying this person logged in, I'm not going to, at some point, look at it. Right? It just doesn't make a lot of sense. Records of transactions, how the transactions occurred, what authentication was used. Again, these are all the little gotcha type stuff that the courts really are looking at.
Does that include logs?
Right, yes. Reproduction of stored images, whether or not they're scanned paper-based original or the original. Because the scan, even though if you put it in the printer and you scan it to electronic, it's not the original. Now we all say, well, yeah, it is. I can look at it, it's identical. No, it's not. Right? And that's what the courts care about. Is it the identical? So evidence must be sufficient, reliable, relevant, permissible, preserved, identified. And the 5 rules of evidence, and this is really what I'm trying to get to here, is the authentication, accurate, complete, convincing, and admissible portions of that. Okay. We got a couple more. I'm going to slide through these quickly. They're admissible, accurate, complete, convincing the juries. Here's a couple terms that's important from a legal aspect. Is also inculpatory. It supports or affirms of your theory. Exculpatory, I can say that right, and contradicts it. And these are what the lawyer is trying to add. So he's going to ask you these type of questions. Is this whatever? And you know, I think we use jargon in our own. When we say a sin, we know what that means, right? When we say different acronyms, we know what those means. But a jury doesn't, or a lawyer doesn't. They have terms as well. What are you talking about? Right? And I guess you can play games with that. Authentic. So can explicitly link files, data to specific individuals and events. Now this is kind of true, and it kind of goes to the sequence of events, and I think I've talked about this in the past, is that, what happens when the police show up, or the FBI shows up and says, we found child porn, and we know when we traversed it back to this IP address, went to the subscriber, he said, this IP address was assigned to you on this date, we got the cert, we got this warrant, we believe this stuff's in here, and they go in there and they find it, right? They find child pornography. There's usually a sequence of events from a defense standpoint that occur. And those usually are, it wasn't me, right? Wasn't there, didn't see it, didn't have any inclination, don't know what happened, right? You've got the wrong computer, you got the wrong product. They say, on this date, this is what happened, and you logged in to your computer or you went to this website, Bank of America, and you logged in. How many people have your password and user ID to log into Bank of America? Here's this additional traffic that only you would know that information. That was you, right? Then they try to throw their child under the bus. Well, that happened, but it must have been my child using my information to log in, right? And then they can prove that no, based on this other network traffic, that was you, right? We can prove that that was you and not your child. It's amazing how many adults will throw their kids under the bus. I guess they figure that it's young and, you know, they don't get as bad trouble with their child because it's maybe the same age, but it doesn't work. Then they turn around and say, well, yes, that was me. I was sitting at my computer, but my computer was acting funny. What do you mean funny? Well, it was going out to these websites. I had all these pop-ups. I must have a virus that downloaded all that child porn. And you're able to prove, well, yeah, but if they download it, it goes to this folder. Somehow those images were moved to My Documents under Sarah under 13 folder, and it's renamed this, and the computer malware does not do that, right? Then they want to plead. And I've had cases, child pornography cases, where they showed up the day of court, and the judge did. They go through everything, right to the point where they're ready to call me up and ask, I want to plea out. Right? I don't want to go through this. And it's gone. People push it that far because they just don't. They think either the expert's not going to show up, or something's going to go their way, or something will change. And they realize it's not that way, and they end up pleading out. So, not good from their standpoint. Accurate, right? You have to make sure the hard drive, the digital evidence is accurate. It's as complete as possible to the original evidence. Again, is it different from other evidence of computer data? So we all know it can change, right? Because if you pull that hard drive at the point in time you pull it, it may be different than if you wait an hour. Right? If you wait longer, it's possible that something can occur and change the evidence. It's basically a snapshot in time. And people do all kinds of stuff about changing the date so that they have some kind of alibi, or they change their system date, system time to last week Friday when they were out at some party and they're doing stuff they shouldn't be doing. And then so the files, and when they're downloaded, the creation date and that may be different than the actual date. So there's all kinds of stuff that go on. Usually you can detect that in the registry and in temp files and unallocated space, where you're able to, a good forensic examiner can detect all that stuff, be able to prove a timeline for that. Evidence can't be altered, it can be changed without digital evidence collection. Computer-created evidence as well as record from it. So again, computers by themselves sometimes create evidence, like in the instance of the USB device, right? It created a record and say that it was accessed last time. Computer evidence creates as many opportunities as it provides threats. Some of those threats are, commercial transactions are recorded or too much. The volume of data that you have to go through and sift through to find the evidence is just phenomenal. Because you can have a computer crime that occurs where it's more than one person, right? You've got, in the instance where, like even in the state, you may have 20 people that were in a meeting and may have created documents of their stuff. And so you have 20 computers that have to be forensically imaged, have to be reviewed, etc. And then each of those is either half terabyte or terabyte big. You've got to sort through all that evidence to create your report for the court, or for your counsel who's then going to present that to the court. Computer-assisted investigation methods become possible because you have all these tools that allow you to look at the evidence as well. So some of those things, changes the metadata, looking at who, on a document, who created that document. And if you go into metadata, the properties themselves, sometimes that'll give you an indication that that was a different person. Some of the timestamps as well. All right, so here's kind of the forensic steps that occurred. You'll see at the top of it, in your initial scope is doing the preparation, securing the scene, surveying recognition of the scene, documenting it, communication shielding, making sure that no one can come into that area or change anything. You have to be aware of volatile evidence collection. The courts are getting a little bit more savvy with digital evidence, and they are saying, so when that person does say, I had malware, right? Well, when they ask your counsel or the forensic examiner or the police, did you look for malware? Did you look at the processes running before you pull the plug on it? And you have to be able to say, yes, this is what we look for. Here's what was running at the time. You have to look for the processes that may not show up in the process monitoring. So you have to look for that stuff as well, because malware can create fake screens of things. And then doing your preservation, or also look for non-volatile evidence, your preservation of the evidence, examination of it, doing your analysis, presentation. Now the presentation again is you've done your report and you're ready to give testimony in court, and whether that's a PowerPoint presentation or documentation, bringing some reports with you to court for them to review or be admitted into evidence, and then reviewing. So in that review, it's usually with the legal staff, and that could be your side or the opposing counsel. Okay, so computer forensics, when there's no explicit intention to create computer records, but a story can be told, locating the materials for use in legal proceedings can be used. So sometimes if the computer records are created and you can't show one-for-one correlation to you actually getting a normal report, if you can show a timeline of things, at times that can be admitted. That's kind of one of those, but it adds credence to the fact that he changed the date on this. And yes, we didn't do a normal report because normally we wouldn't create that type of report, so we had to investigate. So of course, so you're as a forensic examiner, you're trying to produce this report, in which case you are doing investigative techniques. Looking at the audit trails, data from the seized computers, monitoring activities within computers, whether or not they're talking to each other, the networks, analysis of the existing files, timestamps, recovering deleted data. So I talked before about the file table at the beginning. When you delete a file off your computer, it's not deleted, right? What actually happens is they put at the very beginning of the file name in the table at the beginning, you get like a $sign. That tells your operating system that that file has been moved to the recycle bin. Not that it was moved, it's just indicated that that's really prepped to be deleted. Then when you delete the file or empty your recycle bin, what happens is that is deleted on that table. But the actual image, the actual file net still resides on your hard drive. What happens over time is because your computer may put another file and may use where that file was originally on the hard drive, it'll overwrite it. Now when it overwrites, many times it doesn't overwrite everything. So if it only overwrites the first 20 bytes, you're able to then capture the rest of the image. And there's ways to do that using scalping tools, file carving, where you can actually carve out that image, create another bitmap or pen or whatever you're using was the original file format, and be able to produce that image. Now there may be portions that are deleted out of there, but you can still retrieve it and still show that that was child pornography.
Is that still correct, or is that still applicable in solid state drives?
It is, well, there's a time delay, right? Because the deleting of a solid state drive has the collector and the collector, when you delete stuff on there, doesn't initiate all the time. So when you delete stuff, the collector, there may be a delay in it actually deleting stuff. So it still stays there. The way the collector works, though, if it does go out there and delete stuff, it will erase the file. So it works a little bit differently, which is why the NCase tools, the FTK tools, don't work as good anymore with the solid state and moving to mobile technology. Because even so, your solid state drives, the format or that little notch in the drive itself depends on what tool you're going to use to connect. Because based on where it is and how many, I guess, solder points or those little notches there, electrical connectors, some of them I think have 8 on one side, 4 on the other. Some of them are like 6 and 6. So how you connect itself would be different. And so retrieving that sometimes is a little bit harder. But I did have cases where it was intellectual property being stolen. Some guys worked at a company, decided they would steal some information to start their own company, which they did. It was web-based, hosting, et cetera, locally here. So I won't mention the company's name. But the other company found out they were, taking their clients. The remedy of that was to delete their hard copies, which the guys were like, fine, it's better than a $100,000 fine. So, but all the hard drives were SSDs, and it was actually very difficult to delete stuff because I had to show a before image and an after image. And the before was easy because everything was there. The after image, I had to delete that several times before it actually registered that it was deleted. And so when I did that forensic image afterwards to show it was gone, I actually had to do the forensic image like 3 times. Which when you do a forensic image, they're not like, switching a button or turning something on. There's a process you go through because you have to use a pristine hard drive, which is one that's never been used. Which meant I wasted 2 drives before I actually was able to do that. So there's a cost factor with it. But then, it takes a significant amount of time, about 4 hours each time you're trying to do that. And, after a while, you're like, would you just delete? So it was a little bit of a pain, but at the end, yes. And so I presented that. They were all happy. Other questions about what yes?
And also, is the tool that they use physical? You would take the other drive and then you would somehow connect it to the other drive and then use the physical connection
To do what? A forensic image or?
to do bit by bit.
The bit by bit. So there's different tools for that. Yes, you can use DD from a Linux standpoint, but there are tools, and so that's kind of your free open source. The problem with using open source is when you go to court, the Dalbert tests I talked about are not reliable because it hasn't been proven in court that the DD command in Linux would actually work. Right? It
After all this time, nobody used DD?
It's very old.
They have. The problem is the opposing counsel hasn't looked at the methods that were used to do the forensic image and hasn't challenged it. At some point, there will be a challenge to that, and someone's going to have to prove scientifically that the DD command actually does a bit for bit. And they're going to have to get up in court, so when it's challenged, they're going to have to show the court that, yes, here's your hard drives, and they're going to have to go into a hex editor and show where everything was identical, and they're going to have to go through this whole Dalbert test and show the court that that actually worked. Some of the tools that are out there, Celebrate, NCase, FTK, have already done that. So they have, if you go to their website, you'll see documentation that if you are challenged in court, here's where it was previously proven on this case. So go into court with this documentation, and the court can review that documentation and show that a prior court has already ruled on that. And anyone who's been in court knows that and even if you watch TV, right, everything is based upon previous court cases, right? Yeah, precedent. So If it was proven before and not appealed, then that court's will accept it. ED has not been proven. Many of the open source tools have not been proven in courts. Why is that?
Because it is a common and it's so available.
It is common and it is used. There hasn't been a lawyer yet who understands it enough to say, Felder's testimony done on that, let me challenge.
Wow.
Yeah.
What about the issue where next month they come up with their .4.3 version of their software? Does that have to go back through the whole thing because that's not what was clear in the report last year?
Right, so, yeah, so Advocatus has a legal team and has the resources to be able to prove that and be able to, so if it is challenged, they've got everything to help you, because you bought their product. Now, the product is expensive. I mean, anyone who's trying to purchase it, it's very expensive. But they also have all that background as well that will assist when you get to court to be able to help you prove that.
For-profit company, I mean, they've got the funds and cash flow in there to have the attorneys sign, you know, the experts in there to get it through the court.
Right.
We should take something that's an open source, who's gonna come up with the funds and backing and
Right.
gonna pay for the.
Right, and what version was that? And like, yeah, there's a whole aspect to that that hasn't really been challenged. Right? There are a number of great open source tools. Even if you look at like BitPen, which was at one time Cellbrite's competitor, and it was an open source tool, but from a cellular aspect, there wasn't really a lot out there unless you paid, you know, Cellbrite $9,000 to use their software and their many connectors for cell phones or different types of cell phones. It was not that. BitPen was really the competitor. Now BitPen is, you know, kind of gone away because they haven't continually upgraded that. But for your older phone, it still works great. Right? You still look at address book, text messages, things, the file system, et cetera, that are available there. But that was at that time the only thing used, and no one ever challenged it. It all comes down to what the opposing side is willing to accept, right? Because it's, you know, if both sides agree on things, then they don't have to have an expert come in and testify that yes, right? It's getting that commonality, getting that agreement from both sides about what we agree on the circumstances of the evidence. If one side wants to challenge the other, which is what the purpose of going through the discovery phase is and doing depositions, that's part of why they do that, right? They want to see how strong your case is, whether or not you're really an expert in this stuff and all that. And if they feel you're going to get up there and you're going to hurt their case by testifying, they're just going to agree. Or we stipulate that what he's going to testify, we agree to. Right? And that's really what it comes down to. Okay, let me get through this. Collecting evidence, take exact copies. So I kind of talked a little bit about that. Protect the computer system, the original source stuff, and then the discover additional files, printout analysis, access contents, and password protected stuff. So if you have a defendant who, you know, is a bad actor, right? They're not going to provide a lot of that stuff, and we kind of seen that with Apple and in the passcode or the, you know, getting into phones and then saying, well, we're not going to help the police. It makes it very difficult. There are tools out there, which kind of surprised me because there are tools to get around that because you can do up to 10 attempts before it actually will lock you out good. And there's ways even to trick the phone into thinking it hasn't used a time, so they can kind of reset the clock type thing. And as well as, you know, getting into the file system or jailbreaking it to assist with analysis. It becomes problematic for the police to do those actions. I give you, like, for instance, the time I had to go to Facebook and testify for the court, right? We want to set up a dummy account to show, all right, when you log in, this is what you see, this is what you can do, right? The pre-trial, the night before testimony, was you can't do that because by doing that, you've broken the terms of service. How so? Well, you created a fake name. You created a fake person. The terms of service is you don't do that. So you're actually violating the law by helping the court do that. So figure out another way. So, you know, I mean, part of the solution is you have to really create a person. If you already have an account, do you delete your account and then create your account? Or do you use someone who doesn't care that all their information is accessible in an open court? Which, you know, is part of what happened. And so all these instant messages popped up, what are you doing tonight, right? Really wasn't helpful to the court to see that stuff, but it happened.
While you're talking about social media on the phone, they may not have heard the original conversation, but the question, there's two of them. Can you talk about admissibility of social media, such as tweets and Facebook posts? Are they admissible? And then the second question would kind of feeds off of that, which is, can you be compelled to provide the password for Facebook or Twitter?
That goes back to what I earlier said about passwords being, you know, Fifth Amendment, right? Courts have ruled differently. I think the latest one in Virginia was they couldn't compel you. But that's not to say that that could change in the future, because the courts in some jurisdictions, it's been appealed to the Supreme Court as well. I don't think they took it on, but where different courts have ruled differently about whether or not they can force you to do that. The police will tell you anything they want to tell you, right? Because their job is to trick, manipulate, get you to say stuff you don't want. They're not going to say that, right? But they're looking for an end solution. And in their eyes, that's the truth, right? They want the truth about really what happened. So they'll tell you anything they want to tell you as long as you're willing to be truthful. And they're clear. Are you telling me the truth right now? Yes, I'm telling you that this is really what happened. That's ultimately what they want to do. And they'll use any means to get you to that point. Whether or not they tell you, we can compel it, we can have the court do this, or you can just tell us. Whether or not that's a truthful statement is beside the point. Okay? They're going to say that. I mean, ultimately, I mean, they say worse stuff than that, right? But they want the truth, right? They feel they want the truth about what happened. Truth is a perception. Facts are what happened. So, okay, so here's different collection method. Oh, what was your other question? I'm sorry, I didn't mean to dodge it.
More or less about, I think you answered.
The use of social media.
Yeah.
Oh, collecting the evidence. Oh, so a subpoena, does everyone know the difference between a subpoena and warrant? So a subpoena is we think you have the information we want, but we don't know it to be true. A warrant is we know you have the information we want, which is different, right? Because if they get a subpoena to look through your house, they don't really know that you have the marijuana hidden under the bed, right? They think, based on traffic coming in and out of the house, money being exchanged, they think you're a drug dealer and they're going to get a subpoena. They actually know because of an undercover agent purchased there, and he saw you got drugs hidden on, you know, your dining room cabinet. They can get a warrant to say we're searching your dining room cabinet. Now, if you move that, they don't specify where you located it. They can't look there.
Oh, yeah?
Yeah. Now, that's not to say they're not smart enough to say we're going to look in all these spots. But if it's not in one of those spots, they can't use it. Now, there is the open source or plain sight doctrine that says if I see it, you know, you left the drawer open so I could see it was in there, they don't have to have the warrant for that particular spot. But yeah. So in social media aspect, whether or not they can get the evidence, right? If they can log into Twitter and see that you tweeted that, there's different ways in which they can collect that, but they can submit a warrant to the appropriate body, whether it's Facebook, Twitter, whatever, and ask for them to provide that information. Even if you delete it, they can go back, because we saw it on this date. They can go back from a backup and retrieve that. It depends upon whether or not that social media company will charge a fee or not. It's kind of like when you request like a FOIA request, they can charge you for your scans or whatever, right? many agencies just waive the fees if it's not excessive. I mean, if you're asking for a lot of information and just doing the copies alone is gonna cost $5,000, they're gonna charge you. If it's, and I think it's up to $200 is the basis. If it taught, it's $300, they may not charge. It's a discretionary thing. And going to Facebook, et cetera, it's kind of discretionary as well. If in the warrant, they say this is based on a homicide and we need this because someone was, basically bragging about or pride or anything like that, the company may just say, here you go, like go after the person. If it's a little bit more gray, where someone showed up at the airport and they said they were gonna kill everyone, it's kind of like, well, did they ever have prior, arrests? Like it becomes this kind of gray area that the company will provide the record. Well, some of them may not, but in most cases they will provide the records with the warrant. There's all this other legality. Is the server in the United States or out of the country? Do we actually have to abide by it? Do we have to register agent in each state? So all these legality aspects that can be challenged. And that gets into what Facebook's going to do or not do. Okay, so I talked a little bit about hard disk drives and where things are located. I don't have to go through this again. Some of the issues, at least with the older hard drives where there was track width issues, the space between it was wider, so when you deleted stuff, it may not actually delete the whole, number 1 or 0, maybe part of it, which would still show up. So you could delete stuff and it actually format it, but it didn't capture the whole track aspect, so it would still be there. It's not really true when you get an SSD or hard drives or some of the newer ones. The reason being is because to actually add information onto a hard drive, so hard drives are magnetic, and the arm swinging back and forth is based on magnetic and polarity. Well, one really isn't a one there. It's whether or not the polarity being stored on there or the magnetic aspect is actually positive or negative, north or south, right? And the arm coming over detects whether or not it is or not. So, so it's a little bit different, right? But the point is that because of it condensing stuff, there's less false positives and less likelihood that anything would be stored even after you delete stuff. Any questions? Okay, so how's it protected? The forensic specialist has all these different things that they're supposed to do to ensure that your evidence is protected. Your chain of custody, your log of exactly what you're doing, how you're doing it, who had access to the data or the hard drive at any point. So when you store that hard drive, put it in a safe spot that, a lock and key type thing where you only get the key. So you can say to the court, no one had access to that hard drive. The key was always on me. No one could get to it, right? If someone needs to check it out or needs to review that or get into that area for another reason, you have to document it on the chain of custody. And that's important to know. Client attorney information is important. So if you do this at a civilian basis, right, you're doing this because someone approaches you and says, I want you to do computer forensics for me. Your best avenue is to see if they have a lawyer already. Because if you do evidence collection for them and you don't find anything, right? And it's because whether or not you did a good job or a bad job, it doesn't matter. You find nothing, you say, you know what, there's nothing there, and something was there. But let's say nothing was there. But she moves forward with her case and actually isn't going to use that evidence, but it's going to use maybe other evidence that you aren't aware of and moves forward with the case. The other opposing side of it is you didn't have an attorney, it's not privileged information. The opposing side can depose you or have you testify and then ask you, did you find anything on this? No. And then can go off into trying to trick you about it. Is this lady crazy or is this person man crazy? Is he possessive or how did he act with you? And it can actually be harmful to the person who approached you that you didn't find anything. So it's always better to initially say, you need to get a lawyer, if just for the fact that he sends me the email to request this, so that anything I find or don't find is privileged. Because if it's privileged, then the opposing side can't depose you, cannot do that, right? So it's one of the benefits of that. So this forensics, skip through a lot of this. Products have first appeared in the 80s, so it's been around. My point there is it's been around for a while. It's not something that is new. Some of the newer techniques or the techniques today are much different than what was originally used. And we have, from an incident response, from a forensic standpoint, we have toolboxes we use, basically a set of tools to assist us. And then here's some of the different tools that are out there. Some of them are costly. Maresware is somewhat free, so there are some free ones in there. And you talked about the Linux command DD to be able to take one drive and move it over the source to destination forensic image, which again works great, especially if you mount the drive and everything else. I haven't heard of any challenges to it, so it is one avenue. And I've actually
I didn't see the tool you were talking about with the cell phones.
Celebrate.
Celebrate.
CELLEBRITE.
I hadn't heard of that.
Yeah, and it's a great tool. I mean, it's like
For $9,000 over.
Yeah. Yes.
So, as we said earlier about MP5, so in case someone does take an MP5 hash of a hard drive and then brings that to the court, would someone be able to sort of oppose that? Because
well, I think challenging the authenticity of the hard drive, or okay. So
specifically based on that hash.
Well, let me answer. So I understand where you're going, but the point is that when you create your forensic report, right, and that's before you go to trial, right, the opposing side has the opportunity to review that and challenge the authenticity at that time before you go to court, right? So he can say, this report should not be admitted as evidence because of these reasons. And in the report, you have listed how you are authenticating that report, MP5 hash shots or whatever, right? If you only have the one, and he's challenging authenticity, he's going to go to the judge and say, Judge, this needs to be excluded, and here's the reason why, right? And the judge is going to give that to the opposing side. What do you think about this? How are you going to cure that, right? The opposing side or your side, or is going to say, Your Honor, we have the original. If he wants to review the original, he can hire an expert and come and do that. Now, if it's child pornography, right, they're going to have additional controls about whether or not you can actually take the hard drive with you, because they're not going to do that. So you're going to have to go to a secure location, review that hard drive in a secure environment, and they're going to watch you do it, make sure you're not manipulating the hard drive yourself. They're going to have a right blocker, they're going to have all the controls in place. And you can look at the original evidence, the class access state, all that stuff, and run your own reports and do that. If, in the off likelihood, and not that it won't happen, but if the opposing side does not challenge that report off, right, he misses it, he claims he misses it, it goes to court and you're on the stand and he's trying to challenge you on that aspect, at that point, they'll probably stop the trial to be able to resolve that issue and be able to prove whether or not it is or isn't. Sort of the same method I just talked about.
Thank you.
Okay, so some areas of concerns, file systems, the different file systems, the different operating systems, especially when you get into Windows, whether or not, so a lot of evidence is in the registry files, because if you type in a URL versus click on a link, your typed URLs are stored in the registry. So you can actually go to see they actually typed in, go, let's say the sex sites, right? You can prove that wasn't malware or that wasn't clicking the link by mistake. You typed in the URL. So there's different ways to find stuff. Now, where it's located on a Mac system, the plist, PS list, or whether or not it's a version of Windows, things are located in different spots. And workings of application, sometimes on intellectual property type stuff, you actually have to look at code to be able to see whether or not that code is related to this original source code of a completely different program, whether or not they stole stuff, etc. And then besides the hard drives being issued, SSDs are somewhat legit. And then we're getting into the cloud, and it's cloud file storage. And what hasn't been really addressed to some extent is files stored in the cloud and whether or not those are authentic. Because at some point, unless that cloud service provider provides you the hard drive or actually can verify the authenticity of that file, you copying that off, it's a copy, right? So the courts really haven't gotten into that aspect of trials yet. It's probably one you'll see in the future if you are looking at this stuff. If not, I'm sure there'll be cases in the future that people will challenge that stuff. Portable devices, the phones, iPads, tablets, etc. And then different ways of discovery or data discovery, analysis of the data. Timeline somewhat can be tricky to be able to prove different events happen at different times based on creation dates of files, modification dates of files, etc. Many of the tools like NCase of that will give you a timeline based on what evidence you have on the hard drive to be able to map that out. And it's somewhat automatically, it's built into the tool. Okay, problems with proprietary law enforcement. And this kind of goes back to the same issue with whether or not you create your own Facebook ID or whether or not it's a fake one. If law enforcement is using a duplicate and don't have a license to the software, that can be challenged, right? Because you're breaking the law by not actually having a valid license software. If the version you have is law enforcement only, because where that comes into play is Celebrate, NCase, FTK offer lower cost to law enforcement for that. So some people may want to purchase the law enforcement version. It's kind of like buying your educator version, right? If you're not in education field, you purchase those or use those, it can be problematic because it wasn't used for that purpose. It was used in a commercial setting. You have to buy a commercial license. So, not that that can be challenged a lot, but I have seen where they said that's not the right version, right? It's kind of like that's not the right user ID you should be using. And before it even gets to trial, the pre-court thing, it'll be stopped. The judge is not going to allow that. It's not going to allow anything that can taint the trial admitted, right? And so if that comes up as an issue, it's going to think, well, that's skewing the jury's perception.
Doesn't not including that also skew the jury because they don't have the evidence just because you have a version of a license that's not specifically commercial?
Right, but you have to follow the rules of evidence, right?
I'm interested in the truth.
The federal rules of evidence say you have to have that stuff in place, otherwise it can't be admitted. Like you can, God forbid, you can be at Rockingham Palace, have a knife in your car, but because of chain of custody issues and who had access to that knife, it can be thrown out of court because we can't prove whether or not that knife actually went from the van to trial, and whether or not someone planted evidence or planted fingerprints on the knife. So that chain of custody becomes an issue. It's the same type of thing with that, right? If it can't be admitted because there's a gotcha in there, it can't be admitted. And my example was just hypothetical. Oh gosh, my thing is lit up, but it's not letting me go forward.
It's doing something over here. My mouse must have moved. Not on your screen.
Oh, there we go.
Do what you're.
So commercial entrance of the vendor, parity guard for defense. So the defense is part of their thing is, we don't know if the law enforcement version is the same version as the commercial. Is there additional feature in it that we're not aware of? So the parity defense is, we can't use the same tool. No. And then the last was pedophile and whether or not there's issues with that about defendants being able to access that data because of their it being in a controlled environment, right? Police are not going to give. So when you do the forensic duplicate hard drive, typically you keep one copy for yourself for your own analysis, or you provide another copy to the opposing counsel. But if it has like child pornography on it, they're not going to get that out because they would be afraid that the opposing side could use that and replicate, commit crimes with it. Other areas of evidence, print out from system if they're routine, it's allowed, file from remote computers, investigator scrutiny of the internet, undercover activities, testimony, admissions. I don't have too many more slides. Does anyone need to take a break, grab a drink or anything? Or does anyone have to use the bathroom? I hate to always go too long because there's always someone in the room who goes, God. And it always happens. So, yes, let's take a break for just a couple minutes.
You got lots of that.
Okay, are we ready?
Yes.
Otherwise, we'll be here at 10 o'clock, and it's gonna be mad.
It's already on the screen.
Okay, so I'm gonna talk just for a few minutes about different toolkits that are available out there. There's, from an incident response standpoint, a lot of you may already know this, so I'm just gonna go through it quickly. Really from a Linux standpoint, whether you mount from your Linux or VMware type stuff, we will use these tools. They will not modify the target system, so when you use a DD command, they work well, but again, they haven't really been shown, so there's a little bit of a gray area on there. So here's some of the different tools here from Linux systems, the CERT forensic compliance, whether or not you use the VMs for that. SANS has a great one. I think even David, you have used SANS, right? So there's, and they have a lot of different tools you can use. You have basically the VM. There's Autopsy. Now we talked for a second back there about steganography. Does anyone know what steganography is? Okay, so a few use. To the ones that don't, it's basically taking an image using a hex editor and then writing your message in the image. Yeah. So that allows the 9/11 terrorists to have communicated with each other through those images. But it's also one that you have to be aware of, because when you're looking from a forensic analysis standpoint, you have to look at, and you're doing a review of your images, you're looking for that type of thing in the hex, or see if you actually can search for words. Okay, other forensics tools maybe you probably use Wireshark, TCP/Dog, Nmap, Snort. I think you actually mentioned that before. And Tracer. So these, from a forensic standpoint, help to build a picture about what happened. Not that you're going to use every one of these tools, but if you do see, wireless communications, you might use those type of tools for that. So it all depends on what type of case you have and what you're actually looking for, the type of tool you're going to use. Many times, I should say all times, when you have a case, your counsel may, and this word is in the may, the opposing side may produce the evidence for you. So for instance, if they were texting on their phone, they ran in the back of the truck and they got hurt very bad, and they're suing the client. They have to produce their phone because the allegation is that you were using your cell phone. If you want $100,000 out of this accident, if you ran into someone, which happened in Virginia Beach, then you have to provide your cell phone. Well, the person providing the cell phone had other stuff on them, pictures, etc., that they did not want to know, right? So it's kind of like they're warned, and that they're limiting the scope of your review, saying, yes, you can look at my cell phone, but you can only look in this area, right? So what are you looking for? I'm looking for text messages, internet connectivity, you using social media, your web browser, etc. And that's your limitation from the court. Yes, you can do the analysis, but you can only look at this stuff. You're morally and legally bound to just do that, right? You can't go looking to see, what kind of pictures of it you're worried about. What's the big deal here? Always looking, right? It's like you're legally and morally bound to just look at your scope, right? You're looking at internet technology, looking at internet browser, the history, that type of stuff, text messages that occurred around the time of the incident. And so the court will put limitations about what we can and can't do. Because of that, you're going to use different tools, right? If you have a hard drive, they may say, you're looking for access points or wireless connectivity, where did they connect? You can't go everywhere to look at stuff anytime. If it's an open case and the court hasn't produced any limitations on you, then it's pretty well, right? Look at any place you want. Plus, if you're producing the evidence, it's open to you. Now, you may then say to the court, here's the limitations that the other opposing counsel can only look at, because this is what the evidence evidence is, we don't want them going off and seeing that, you know, the commissioner of some agency typed up some bad stuff, right? This is where you can look. All right, so here's another one by Sands, right? It's pre-configured, VM appliance, it works very good. And it has a lot of open source tools with that. Acquisitions, again, the DD command and how that works. A couple other tools there, Helix, Belden, and somewhat are minimal cost versus comparing that to FTK. Well, FTK and NKs have the acquisition portion, it's an analysis. So you can create your EO1 files, but then you can't do anything with them. So, you know, what's the sense? File carving, again, this is, you know, looking at the ones and zeros to be able to produce your image, but also to see if there's messages in there. That we use for Moser scale to be able to look for that stuff or carve out your image based on the file header or file type. When you use that, you know, you're using certain commands, at least in the DD command there on the third bullet there, you'll see the DD command to be able to carve that out to another file, to be able to review. And it creates a directory with a lot of text, so you can see subdirectories as well. I talked about stenography, hashing using MD5D, RAM analysis. And RAM analysis is becoming more prevalent in the courts because of malware or possible malware that could be on a computer. So in court, I'm go into this date or not, but I'll try to gloss over it because it's not really the security aspect of how you guys are caring about. But when you do go to court, here's some of the things from a deposition or what the court's looking for and how to tailor yourself for the court, at least based on my own perceptions in that. So may not be 100%, right? Preparing for testimony, all right? So they're going to ask for technical or scientific evidence. It's based upon what you can provide evidence to, right? Whether or not you can draw conclusions or whether or not you can just get facts about what you said. There's a difference in that, right? Because if you can just go in there and say, this is what was found, you can't say your conclusion. They can't say, well, based upon this evidence, what do you think happened? Now, if you are certified to do that, and certified as an expert, then you can draw conclusions, right? And you can draw any conclusion you want, right? You can say, well, looks like, you know, his mother brought him coffee at 2 o'clock in the morning, right? I mean, sometimes your conclusion you would think doesn't even bear based on the evidence, but it's based upon that expert's opinion. And that expert has to be certified. There's a process for that, and I'll talk about that in a second. In theory, it works for the court. In reality, it works for one side or the other because an expert witness is supposed to be unbiased, right? So while the prosecution or the defense may call the witness, he's supposed to be independent. So as an expert witness, you don't care who wins. And when I've testified in the past and when I've worked with lawyers, I say up front, I do not want to know what the case is about. What's my scope? What am I looking for? And let me draw my conclusions. Let me look at the evidence before I find out what happened. Because I don't want it to taint my own objectivity. And it's very easy to do. Like if you find out this guy molested his daughter and they're looking for stuff, your mind just goes completely one way and you're like, all right, I'm not going to help this guy. But you're hired for the court. You're supposed to be there for the judge because the judge doesn't have that expertise. So an expert witness is working for the judge. And so it's better not to know that stuff. Trust me, it is. And so when you're working on that stuff, when you're doing all this stuff, after you create your report, then you kind of say, all right, what's this case about? I may end up in court over this. Then you're going to find out. And you're like, well, I'm going to track that thing, right? But it's already done. So doing it in an objective way is better for the court, better for justice, ultimately. You want to confirm your findings with documentation and corroborate them with your peers, right? Because as an expert witness or someone that's up there, it doesn't look good if you have an expert with the same background coming up and saying exactly the opposite you have, thing, right? I mean, then it does look like you're favoring one side. And typically, you know, a lot of these expert witnesses are part of different groups, right? Because they're trying to be professional about it. And they talk among themselves about, you know, I have this case, and they don't talk about all the details, but they do try to say, in these type of scenarios, what would your conclusions be? Is there anything I'm not looking for, or I should be looking for that I'm not? Like, you know, did I miss something? Am I drawing the wrong conclusion? And so they try to help each other out, even if they're not going to be called as an opposing expert. They try to help each other out so that the expert has as much knowledge as possible to draw its conclusion, which ultimately is better for both sides. Great, the curriculum vitae is the court's way of saying the resume and the strengths and weaknesses of your resume. So when preparing your testimony, consider all these different, you know, questions in your mind. What is my story of the case? What can I say with confidence? What can I say? What is the client's overall theory? How does my opinion support that case or differ from the case? What is the scope of the case? Again, going back to the scope. Have I identified the client's needs for how my testimony fits into it? Because in some respects, you know, you're obviously, and if you're paid or not paid, so if you're working for the state, a little bit different, but if you're paid, the opposing side with your report is going to know what questions he doesn't really want you to ask, right? He's not going to ask you on the question of, you know, how did you derive that report? Why did you come up with that report? He's going to leave that portion out and hope the other side doesn't question that. So, and that's kind of where working with the lawyer helps him define his questions. It's really, you know, making sure the perception for the jury is the right perception.
A minute ago, you said working for the state, not getting paid.
Well, you're getting a salary from the state, right? But many times when you're, so you're getting your salary, whether or not you testify or not testify, right? Whether you're in court providing your testimony, or whether you're not, you're back at the precinct or wherever working on the case, okay? You're getting the same salary. Whereas when you're working for maybe the defense, they may be paying you $250, $500 an hour to provide a testimony. So that can look like your testimony is being bought, right? And you don't want that perception, because if you really want to be, you know, treated in a reliable manner and in a professional manner, you don't want that to be part of the process, or thought process. Okay, so preparing your evidence, documenting your steps, I talked about that before, listing out everything you've done from beginning to end, preserving it. Do not use a formal checklist. Why? Because if you forgot to check a box, then the opposing side is going to use that against you. Why did you do this step? What is the impact of that? You're just going to be grilled for a day on you didn't follow your own process, right? So many times while you may have a formal report, the process you're using is in your mind. Here's what I have to do, here's what I have to do, right? Because you just don't want that, you don't want to depose, because the opposing side is going to take your checklist of things and go to another expert and say, is this the right checklist? If you got one thing out of order, it can mean the evidence is thrown out, right? So making them bring you up on the stand, asking for what you did is much better for the case. Again, the checklist is discoverable, opposing attorneys can challenge them. Collecting evidence and documenting employed tools, right? What tool you use, how has it been validated in court or not, and maintaining your chain of custody. Collecting the right amount of information. And on your terabyte information, you're not going to bring up the fact that, you know, if it's intellectual property, you're not going to bring up the fact that you're viewing porn sites. Yes, it was bad for that guy, even if it was child porn,
It's not your scope, and you shouldn't even be putting that in the report. It's not your scope. Date and times of when you started your analysis, again, everything you do is documented. And then keep it on a successful output. You're not gonna say, well, you know, in the case with the 3 hard drives, that 2 of them were unsuccessful. I'm not gonna provide that in my report. I'm just gonna say, you know, maybe after several attempts, I was able to successfully delete the files, and here's, you know, proof that it occurred. I want to document too much. Again, documenting too much opens the door for challenges. Keep your notes simple, use only relevant evidence, define a procedure to use to conduct your analysis as scientific and conforming to those standards, right? Honor, preserve, and validate your work, and validate your evidence using hashed algorithms. So whenever you can use scientific procedures, use those because those have been proven in court. Whether you're a consulting expert or an expert witness, don't record your telephone conversations. What the courts, in my experience, have wanted to see is your experience, your published writings. So in your resume, documenting the more things you've done, even if you have a blog on security, right? Document that you have a blog on security, and here's the different types of posts I've done. Did a post on Snort, I did a post on Bright, and documenting that just gives the perception that you're more of an expert than the guy who didn't do that. Doesn't mean you are, it just means the perceptions are. Training, education you have are important for, you know, the jury. Obviously, if you get up there and you say, you know, I've attended all these courses, I've done all this additional training, all these certifications, it's a whole lot better than the guy who doesn't. And the perception aspect. Learn about all the other people involved, the basic points in dispute. Brief your attorney on your findings and opinion of other experts if known. So, you know, you want him to know your weaknesses as well, because he's not going to highlight those, right? But he needs to be aware of them in case they're brought up. There's a lot of, I won't say bad lawyers, but there's a lot of not incompetent.
We can agree.
Right, we can give all the lawyer jokes we want, right? But there are better lawyers than other lawyers, and that's all I mean. And the better lawyers cost more. So they're the ones that are going to do all the challenges, everything else. Your ones that may not cost a whole lot are just, you know, in it for the paycheck. They may not care about a lot of this stuff. Again, your resume, which is your professional experience, qualify your testimony. I will say, on all the stuff you provide the court, be 100% accurate, because the opposing side is going to look at every word on that resume and validate every word. If you don't live at that exact address, don't say you live at that. You know, if you live with your mom and you're like in the process of moving, don't put the new place on there, right? So everything on your resume has to be factually accurate, because you will be challenged. The other side is looking for that gotcha to disqualify you, and they will throw out everything you've done. And your employer is not going to be happy with that occurred. Most likely, it's sued. And you're hoping you have insurance, errors, and omissions, because you're going to end up, whatever that person could have won, whether or not it's a freedom or whether or not that's money, you can get sued for. You know, continuously enhancing your skills, include a testimony log of things you've done, books you've read, etc. Again, you just want to get the perception that you're better qualified than an expert, the opposing counsel's expert that may come in and say something contradictory to you. Technical definitions, I think we all may be aware of this, right? When we're talking to our business users, we don't talk about all the technical jargon, we kind of dumb it down for them. Judges, lawyers are the same way. So you know, when you're talking about file stack or unallocated sectors, all the stuff you may care about where did you find that evidence, right? Well, it was deleted in remnants or unallocated space. What the heck is that? You just talk Greek to me. So yes, you want to dumb it down for them. Other terms that they are not aware of that you're like really, like You don't know what a URL is, right? So you don't know what a file system is, you don't know what an operating system is. But there are a lot of people that don't understand the difference between an operating system and, or what the purpose of an operating system is. Why do we have an operating system, right? Basically, the interface between the hardware and your software. But people may not be aware of all this stuff. Legal actions generate interest from the news media, so you may be happens more often than you want, where there's a reporter, and I swear it says that every court waiting for the opportunity to get their name in the news, get you on film, right? No time, ever, right? You want to be invisible. In fact, you don't want anyone to know you're the expert witness. Number one, you don't want to get beat up at recess or when they break for lunch, but you also don't want, the reporter harassing you while you go out and, you're eating lunch and they're filming you. Oh, he likes, avocados for lunch. I mean, it's unnecessary and just as a distraction. Testifying in court, procedures during a trial. They present you, opposing makers try to discredit you. Even after a pretrial, he's like, you're good to go. You can testify. And then he gets up there, and every word that was not good is going to make you look bad on the stand. And in this day and age, like social media, once it's out there for good. So if you are challenged on the stand, you most likely will never be called again on the stand. Because your testimony is going to come with you. Because your next case, that lawyer will say, did you provide testimony on this date? Did they ask you this question? Did you say this, right? All that stuff is relevant to this because that's part of your reputation. So, obviously you never lie on the stand, but the point there is you have to be careful about what you're testifying to and make sure it's accurate. Understand the trial process and the different orders of the trial, right? So, looking at getting the jury in there, the opening statement, plaintiff, defendant, the different ways people are up there, closing arguments. Most likely, all this stuff, you are going to be sequestered out of the room. The opposing side does not like expert witnesses in the room. So they immediately, at the very beginning, typically even before the jury is Your Honor, and I forgot what it's called, but it's basically, we don't want any of the witnesses hearing each other's testimony because there could be corroboration between them. If you hear someone testify, on this date at this time, in your mind, you tell us where you thought it was 10 o'clock, you heard 10:15, you're going to say 10:15. So they don't want, that linking to corroborate each other. They want you to come in and one testify 10 o'clock, one testify 10:15. And the juries are divided.
Intimidation.
Right, exactly. So they make you all sit in the green room outside where a court bailiff stands there to make sure that none of you talk to each other. Or if you do talk to each other, it's about the weather. Right? It's not about the trial. And you're told, do not discuss this at home. So, providing qualifications beforehand for your testimony, you can prove that you're an expert witness. Attorney asks for the court to accept you, and the opposing attorney may try to disqualify you. Typically, even before this, your resumes provide the other side. They're actually able to, the night before, to Google you, and when the opposing side, even before you go to court, the opposing side may say, "Can I talk to you for a minute?" And he's going to say, "I found this on the internet, and I'm going to talk to you about that on the stand." So you kind of got a heads up that they found the whatever is out there. So it's like, again, if it's out there, you're going to be asked. Testifying, so you have to be conscious of the judge, the jury, the attorney, right? Now, you may have seen this even on the Hollywood type stuff or in movies, on shows where you kind of see them up there and you know based on the perception of their testimony, whether or not you believe what they're saying, based on their actions, based upon what they're saying, how they're interacting with the jury, etc. Again, all that is kind of theatrical, in my opinion, but it provides a professional environment. They have to be able to hear you, so you have to talk very loudly. Loud enough that this would be considered quiet, right? Because it's almost like they're on the other side of the room, but it's a much bigger room than this, and it's almost like you're screaming at them. And the microphone they provide you, unless you're down like this, it doesn't pick up your voice the way you think it does. So you don't want the jury to think that you're weak in your testimony by not talking loud or not getting your point across in a convincing manner. Be professional, play, make sure your delivery and presentation to the jury is on point. So your movement, turn towards the questionnaire and then turn to the jury, right? Because typically, when you're on the stand, you're going to have opposing counsel, the defense here, and so you turn to them. Jury's usually over there, and they don't have to see the side of your face. Plus, your voice is going this way, and it's a big room out there. You better turn it back to them and say, "All right, let me address that," and then give them a clear, convincing answer to it. Which isn't really as hard as you think. Like, it's usually, the questions before, right? And you've kind of thought of, all right, when you ask me this is how I should deliver, this is what I should say. When opposing counsel gets up there, that's when it gets a little bit different, right? Place the microphone closer to you, use simple, direct language, repeat, build repetition into your explanations. Use chronological order to describe the events. Don't talk about something last year, then tonight, and then 2 months ago. You're basically trying to tell a story. So when you tell a story, even if it's once upon a time, you don't jump to the future and then back. Right? You build the story up. All right, dressing, obviously professional, don't memorize your testimony. It's even, even given a presentation like this, right? I don't get up here and memorize this. Put together the slides, I see them, oh yeah, I'm gonna talk about this, right? But you don't memorize anything. State your opinions, make sure they understand those were your opinions and not, so like when I said, this is my opinion, I'm kind of doing the same thing as you would in court, right? You want to make sure that there's a clear delineation between the facts and your opinion of things. Prepare your testimony with your lawyer or the attorney, how the data is stored out. So all that stuff, right? You're going to educate him on all the technical stuff so that he's aware of it. So if it comes up, even if you don't provide it, and the opposing counsel has an expert witness as well, or the police officer or whoever, and he brings up these terms, the lawyer doesn't sit there going, time out, what does that mean, right? He doesn't have that opportunity, so you have to educate him beforehand about what he should know about this case and some technical aspects so that he can respond quickly, whether or not it's motion or whatever the case may be. Try to use graphics. It's a little bit hard at times, but try to make it clear, easy to use. Like any PowerPoint presentation, you don't want to use too many words on the slide. They have to be able to see it, from back across the room. So you just want to make sure that it's easy to see and that you get your point across. Testimony problems, right? Recognize when you have a conflict of interest, avoid agreeing to a case unless you're under contract with that person. Again, attorney-client privilege, avoid conversation with opposing attorneys unless your attorney knows about it. Now, how I get around that is, and I provide explanations to the opposing counsel because I don't want all these questions up there when they don't understand what I'm going to testify to. But when I provide my report to the court, right, and the opposing side gets the report, and they say, I just want to talk to you about, you made this comment in here, I don't understand what that means, right? I don't really provide an explanation other than what does it say in that paragraph? That's what I'm going to testify when I got on the stand, right? I'm not going to add too much to that. I'm providing exactly. And so they can ask you questions about that, but you can redirect back to what was provided in the report. So, even if they say, well, I want to talk about these other stuff, that's not the scope, right? I'm going to provide testimony, and the exact testimony is based on my opinions and what's in the report. So I'm not going to deviate from that. Usually, within 5 seconds of talking to the lawyer, you realize you're not going to answer his questions. It's like, all right, thank you for your time, and he hangs up. He doesn't even say goodbye usually. So don't talk to anyone. So don't give your opinions on things. Oh, did you see so-and-so was sleeping? Type stuff. Just keep to yourself. You can make those afterwards if you want, but not during the trial.
Why do you say you should receive payment before that?
What's that?
There's a bullet on the last side that said, get paid before you testify.
Yeah.
In case your case doesn't go the way it should, right, and you lose, that person doesn't want to pay you, right? Because he's lost. He may have to go to jail, or he may have to, and so if you're on defense. But if it's a litigation where he's sued for millions of dollars and think, all right, I'll mortgage my house to pay for a lawyer and this and that, and he loses, figuring he's going to repay that with his winnings, he loses, he doesn't want to pay you. So the way, from the civil defense of working as a private citizen doing this stuff, I work the same as a lawyer, right? Give me a deposit and I draw against it as I'm working. And if that runs out, I need more money. If there's any money left at the end, I'll return that to you. But for me to work, I'm
Retain.
well, that's what it's called, yes. And lawyers work the same way. And so that's what I tell them. I work the same as a lawyer. And the lawyers get that as well. So usually what the lawyer does, because you, in essence, are paid from the lawyer will do a draw against his retainer and provide that money to you. I did have a case where it was a music piracy. I know you probably heard this, but it was the only music piracy that FBI lost. And unfortunately or fortunately, I was on the defense side of that. And it was a delicacy, it's in Wikipedia, where there was a group of people that were stealing music. And the FBI thought it was Del Cassane who did it, and it wasn't him. He was a part of it. What happened was one of the people in North Carolina flipped and was providing undercover work for the FBI and tape record and everything. And so tape state testimony, and he was basically setting up. So what was happening, there was 2 guys in North Carolina that were stealing music out of a warehouse that were distributed to the music stores. They would take home a CD, cassette, whatever, and make a copy of that and bring it back. So there was no stealing of anything. They just made a copy of it. They would upload that music to Adele, who knew enough about security to put it in the right folder, and then right-click on the folder to give the right people the permissions to the folder through an SFTP server and all that stuff, right? So because he was doing the most of the work and communicating out, the FBI thought he was the ringleader. He wasn't the ringleader. He was working customer service, making $13 an hour, who just knew enough about security to know how to right-click on stuff and change properties on a folder. It's about the extent of what he did, right? You almost got to feel for him because you can almost see yourself, I'm just helping someone else out. It's, what harm am I doing? It's just music, right? I don't even know, right? But anyways, Rapid Neurosis was the name of the group. And they actually came, am I talking Brandon? So Rapid Neurosis actually produced a song from Eminem, well, before he actually released it, and then Eminem went on MTV and was all upset that this group had released his music before he did. But they made the members overall were charging people to download music, and so they made a little bit of money. The venue was changed from Virginia to Texas, and when it was changed, the rules kind of changed a little bit, and the FBI ended up losing the case because of it. Not the greatest story for the FBI. Again, it's the only one they lost. I think if they handled it a different way, they probably would have won, but they didn't. The only one who actually did time, the guy who flipped. He actually did like 3 years or something like that. Everyone else got off because they
That is good justice.
yeah, well, I mean, kind of how you look at it, right? Because they were looking for a lot more time because of the number of files and the piracy and everything else that they thought they could afford to give them.
Sharing is caring.
There you go. Initially, also don't talk to them. If this information isn't disclosed to the defense attorney in a reasonable time, you can report it to the prosecutor or supervisor. No further. So, again, you don't want to get caught, but yes, evidence should be provided to those sides if you're on the prosecution side. Doesn't mean you have the authority to give that information, so you can't be a word snowed because you'll end up in Russia. Not that many, I'll go quicker. So techniques: work with your attorney with the right language, present your background qualifications, use your own words, be prepared for challenging. Attorneys make speeches and phrase them as questions. Right? You'll see that quite a bit, especially on like Perry Mason. So here's some questions on depositions. I'll go through these a little bit quicker, maybe just apply to those. There's different ways to prepare yourself for those, and I'll provide these slides so you can view this stuff later. So any questions?
That was a good presentation.
I have a question on the acquisition of RAM. So that's more and more important.
Yeah.
How do you acquire RAM during an investigation to present in court?
So there are tools to do that, to look at RAM and look at the processes running, and you could use the output of that to show that you did look at that stuff. I have seen cases where they actually found malicious software, although it was benign. Nothing. It's kind of like, sometimes you're running malware fights and suddenly detect something, you're like, that's been there for God knows how long. Why did I find it now? It was one of those where there was stuff on the computer that had been there a long time, so it was kind of benign to the case itself, but they could show it wasn't running a process. But we still provided that to the opposing counsel, and, as part of complete disclosure that yes, we did see something, but nothing to do with that, and that malware doesn't do that stuff. So it does happen, and it happens quite a bit. You just have to be able to prove that variant, and you can actually, we use in VMware, and you can run that application to show the malware running, and that it's not downloading stuff, it's not doing what he's alleging it's doing. Yeah.
So is that good has to do with virtual environment, because most malwares have capabilities to detect whether or not there's a virtual environment and not execute.
Right. So there are you can get the keys and run that in there. Bring up the actual forensic image copy and run that in court as well to show exactly what it's doing, which is actually better to do because running in VMware, the opposing side can say that's not exactly what the person saw or what is actually running. And courts don't know enough about VMware or virtual environments that many times create your duplicate and running that on a computer. You do run into hardware conflicts with doing that because if a printer was installed, so for that printer, so it's a little bit more challenging, but it's probably about kind of go if you want to show it in court. Any more questions? Okay, awesome. Thank you.
Thank you.
Thank you.
to say it's one of the best presentations we've had.
Probably the longest too.
It is.
Sorry.